Law of Public Schools. Chapter 1. Taxation for Public Schools. 1. Brief history of the subject. The thought that man as man, without reference to any special practical end, should be educated seems to have occurred first to the Greeks. But it was not until the Reformation that men began to hold the opinion that every man intellect should be so trained as to be able to read and inquire and think for itself. During what are called the Dark Centuries, a state of deplorable ignorance prevailed all over Europe. It is refreshing to find in the history of this dark Middle Age two monarchs who strove to give to their subjects the inestimable privilege of lifting themselves out of the depths of ignorance in which they were immersed. At the accession of Charlemagne to the throne of France, no means of education existed in his dominions. This monarch, who, it is said, was himself incapable of writing, invited men of letters from abroad to come and reside at his court and instruct himself and his family. He also established schools in various cities of his empire. In the 9th century, Alfred the Great, of England, made similar efforts, but they died with him, his successors being too much occupied with warfare to continue the educational work thus initiated. Down to the time of the transitional movement in Europe from the medieval ages to the modern world, there is little of interest to the cause of popular education to record. The influence of the Reformation upon education was made manifest early in the 17th century. In 1616 the Scotch Parliament adopted measures for settling and supporting a public school in each parish at the expense of the heritors or landed proprietors. This legislation was repealed at the Restoration of Charles II, but was reenacted by the Scottish Parliament in 1696. Lord Macaulay says, "By this memorable law it was, in the Scotch phrase, statutated and ordained that every parish in the realm should provide a commodious schoolhouse and should pay a moderate stipend to a schoolmaster." The effect could not be immediately felt, but, before one generation had passed away, it began to be evident that the common people of Scotland were superior in intelligence to the common people of any other country in Europe. To whatever land the Scotchman might wander, to whatever calling he might betake himself, in America or in India, in trade or in war, the advantage which he derived from his early training raised him above his competitors. If he was taken into a warehouse as a porter, he soon became foreman. If he enlisted in the army, he soon became a sergeant. Scotland, meanwhile, in spite of the barrenness of her soil and the severity of her climate, made such progress in agriculture, in manufactures, in commerce, in letters, in science, in all that constitutes civilization, as the Old World has never seen equalled, and as even the New World has scarcely seen surpassed. This wonderful change is to be attributed, not indeed solely, but principally, to the national system of education. Since then every great power of the civilized world has adopted some system of public schools. What little objection has been made to taxation for universal education, in this country, has come from wealth, which says it cannot properly be taxed for the education of the people. We must not forget that without law the ownership of that wealth could not exist. Jeremy Bentham says, "The idea of property consists in an established expectation, in the persuasion of being able to draw such or such an advantage from the thing possessed, according to the nature of the case." Now this expectation, this persuasion can only be the work of the law. I cannot count upon the enjoyment of that which I regard as mine, except through the promise of the law which guarantees it to me. Property and law are born together, and die together. Before laws were made there was no property. Take away laws and property ceases. The words, "I cannot count upon the enjoyment of that which I regard as mine, except through the promise of the law which guarantees it to me," come home with significant meaning in this day of socialism and of clashing between capital and labor, which now so often occurs in the monarchies of the Old World, and even in our own land. The law guarantees the right of property, but instantaneous with the creation of the right of property must exist the paramount claim of the government to such portion of it as may be necessary fully to effectuate that guarantee. The law must be upheld and respected, or else all rights of ownership are in jeopardy and industry paralyzed. To maintain the law, education of the people is more potent than standing armies. Lord Brougham, in the House of Commons, said, "There have been periods when the country heard with dismay that the soldier was abroad. That is not the case now. Let the soldier be abroad. In the present age he can do nothing. There is another person abroad, a less important person in the eyes of some, an insignificant person, whose labors have tended to produce this state of things. The schoolmaster is abroad and I trust more to him, armed with his primer, than I do the soldier in full military array, for upholding and extending the liberties of his country. It is intelligence," said Daniel Webster, "which has reared the majestic columns of our national glory, and this alone can prevent them from crumbling into ashes." State education, being so important to national existence, is therefore a very appropriate object of taxation. 2. Power to tax for school purposes. The state is the source of authority. Every municipal corporation and every political division of the state must be able to show due authority from the state to make the demand. The taxing power can be lawfully exercised only in behalf of a public purpose. Boards of school directors are civil corporations, and the legislature may confer upon them the power to tax for school purposes. The words public schools are synonymous with common schools, and mean the schools created by law and maintained at the public expense, and which are open and common to the children of all the inhabitants alike. Taxation for public schools is for a public use and purpose, and public education is a fit and appropriate object of taxation. Such taxes may be constitutionally imposed, and one receiving his full share of benefits from the school system cannot complain that the legislative power is in that respect unwarranted. There can be no taxation in aid of a private educational institution operated for individual profit. That a school building was larger than was immediately needed, and that the vote specified among other uses of a part of the building that of holding school society meetings and lectures therein, does not vitiate the tax, nor authorize a court to enjoin the same. A vote by a school district to raise a given sum to remove and repair a schoolhouse is within the authority granted by statute to raise money for erecting and repairing schoolhouses. Where the law provides, as it does in some of the states, that the electors of a school district, at an annual meeting, must vote a precise and definite sum as a tax on the inhabitants of the district for building a schoolhouse, they cannot delegate to the officers of the district any discretion as to the aggregate amount of tax to be raised. In Michigan, the policy of the law of that state upon the subject of education, from its organization until after the adoption of the present Constitution, was reviewed by the Supreme Court of that state, and the court came to the conclusion that there is nothing in the Constitution or laws of that state restricting its school districts in the branches of knowledge which their officers may cause to be taught, or the grade of instruction that may be given, if the voters of the district consent to bear the expense, nor is there anything to prevent instruction in the classics and modern languages in these schools. In the same case, the question of whether there exists any authority to make high schools free by taxation, levied on the people at large, was fairly and fully raised, and the argument urged that, while there may be no constitutional provision expressly prohibiting such taxation, the general course of legislation in the state and the general understanding of the people have been such as to require the courts to regard instruction in the classics and in living modern languages, in these high schools, as in the nature, not of practical and therefore necessary instruction for the people at large, but rather as accomplishments for the few, to be sought after in the main by those most able to pay for them, and to be paid for by those who seek them, and not by general tax, and that therefore the court sought to declare such taxation incompetent. After hearing full argument, the court decided that such taxation was proper and lawful. In considering the applicability of the decision above referred to, it must be borne in mind that there is nothing in the state constitution, or in the history of education in Michigan, different, so far as the principle therein settled is regarded, from the constitutional provisions and educational histories of many of the other states of the Union. There are many other decisions in which the power to vote and grant money by taxation for the support of grammar schools, high schools, and normal schools, has been liberally construed by the courts in aid of such institutions. Indeed, it seems practically to have been adopted as a rule by the courts that the law shall be liberally construed in aid of such objects. In an early Massachusetts case it was decided that money raised for the support of a female high school, for the purpose of teaching bookkeeping, algebra, geometry, history, rhetoric, mental, moral, and natural philosophy, botany, the Latin and French languages, and other higher branches, was lawfully raised by taxation. As early as 1636 provision was made in Massachusetts for a public school, which 2 years later, receiving a bequest from John Harvard, was called Harvard College. To the end that learning may not be buried in the graves of our forefathers, in 1647 it was ordered in all the Puritan colonies that every township, after the Lord hath increased them to the number of 50 householders, shall appoint one to teach all children to read and write. And where any town shall increase to the number of 100 families, they shall set up a grammar school, the masters thereof being able to instruct the youth so far as they may be fitted for the university. The great historian of the United States says, in these measures, especially in the laws establishing common schools, lies the secret of the success and character of New England. Every child, as it was born into the world, was lifted from the earth by the genius of the country, and in the statutes of the land received as its birthright, a pledge of the public care for its morals and its mind. In 1817 the town of Dedham was indicted for failure to maintain a public high school. High schools thus originated almost with the settling of the colonies, and are now maintained in the various states and territories. and no question has been made as to the power to tax for their support, except in the cases previously cited, in which that power was upheld. It may be said that in the case of Rulson v. Post, the Supreme Court of Illinois held the contrary so far as that state is concerned, but an examination of that case will disclose that the writer of the opinion was not called upon to decide the question, and it cannot be considered as more than the private view of the writer of the opinion. It should be said, to the credit of that state, that it is one of the foremost in secondary education, and its many high schools are cheerfully supported by taxation. A power that is thus coeval with our government, which originated with it, and has been constantly exercised ever since, cannot now be doubted. Most undoubtedly, the legislature of a state has power to tax for the support of public high schools, and this power may be delegated to school districts as civil corporations. In the course of an opinion recently delivered in the Federal Circuit Court for the Eighth Circuit, it was said by the court, "It has long been a recognized fact that the order and well-being of any community largely depended upon its moral and intellectual culture, and nearly all nations making any pretensions to civilization have in some way or other recognized this. The encouragement usually was in keeping with the prevailing form of government and social organization. As these became modified, so as to distribute burdens and benefits more equally, educational interest came in for a share of its favors. Not, however, until intelligence had demonstrated its physical power, beyond cavil and dispute, did education obtain the universal recognition it deserves. Organizing armies and schools, improving implements of war and the schoolmaster, became equally of national concern. At the birth of our government, education had not obtained national recognition, for beyond the promotion of science and arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, no attempt is made in the Constitution of the United States to draw education within national cognizance, thus indirectly delegating it to the states. In them it found more or less favor. Until today there is not a state in the Union which fails to recognize its importance. In the same case it was held that the fact that free schools and a state university are expressly mentioned in a state constitution, and normal schools are not, does not amount to a constitutional prohibition against the establishment of the latter.